Welcome everybody to this session of Trinity Talks. My name is Luke Muchamore. I'm a partner here in the London office of Trinity. I've got the honour of introducing today's topic and our speakers. Our session today is going to be talking about foreign exchange regulations in the CEMAC and UEMOA regions. Our Francophone practice, based out of Paris, is seeing a new trend in the enforcement of these regulations. And so we'd like to take you through today the session with two of our Paris office partners, Mariana Sedefian and Lucien Bouchaya. A couple of housekeeping points to begin with. Please be aware that the session is being recorded. It will be uploaded after the session to our website and will be available there. You can ask questions using the Q&A function in Teams, and what we'll do is we'll keep those to the end, and I will raise them with our panelists who will try to deal with them. So without further ado, that's it for the introduction. I will pass you on now to the first of our two speakers, that's Mariana, who will kick things off. Thank you. Mariana.
Thank you, Luke. Good afternoon, everyone. I'm extremely happy to resume our Trinity Talks today with a quite, I would say, technical subject, but also quite important, which is the foreign exchange regulations. We will focus today with Lucien on the CEMAC and UEMOA countries, which are the both Francophone zone in Africa. And so after a brief introduction of what is UEMOA and CEMAC, I will give you an overview and compare both regulations, foreign exchange regulations in UEMOA and CEMAC. And then I will hand over the microphone to my brilliant colleague, Lucien, who will explain what are the new updates with respect to the foreign exchange regulations into the extractive industries. So let's start with a brief introduction. So what is UEMOA, what is CEMAC, why foreign exchange regulations? Just ask the question. And what have been the evolutions of the UEMOA and CEMAC foreign exchange regulations? So just to start with the UEMOA, which is the West African Economic and Monetary Union. The UEMOA is comprised of 8 member states: Benin, Burkina Faso, Côte d'Ivoire, Guinea-Bissau, Mali, Niger, and Senegal. This regional economic organization has been created in 1994, and the common currency obviously is CFA franc, and the central bank is BCAE. There is a common objective, which is to create a common market between the member states, which is based on the free movement of persons, goods, services, and capital. Also, one of the major aim of this economic organization was to liberalize the economic and financial activities between member states and to regulate the foreign exchange. Just to see what is the legal framework of UEMOA. Next slide, please, Luc. So you can see that here there is a full hierarchy of norms, legal norms. It is starting with the treaty, which has been signed, as I just said, in 1994. And there are additional acts, regulation, directive, etc. The principle is that the acts adopted by the organs of the UEMOA to achieve the objective of the UEMOA Treaty shall be applied in each member state, regardless of any prior or subsequent national legislation to the contrary. Now let's move to the CEMAC. The same provisions as I just mentioned for the UEMOA countries. The CEMAC, this is also a regional economic organization that has been created in 1994 as well, and it is comprised of 6 member states: Cameroon, Central African Republic, Republic of Congo, Gabon, Equatorial Guinea, and Chad. And the objectives are exactly the same as for the UEMOA, mainly to liberalize the economic and financial activities of member states, and to preserve the external balance and also to regulate the foreign exchange. As for the UEMOA, there is a full hierarchy of norms here. The treaty, additional acts, frameworks, regulations, and the principle is still the same. those principles will be applicable in the member states, notwithstanding again any contrary national legislation. As regards the foreign exchange regulations, these are implemented from, as I said, the regulations. But one can just ask the question, why foreign exchange regulations? I would say that the idea is quite simple. Those regulations have been adopted to ensure a transparency of financial flows, to ensure as well a traceability of currencies. They have been also adopted to ensure external monetary stability and a balance of payments, and finally to strengthen the control over foreign exchange reserves. And if we have just a look to the next slide, we will see how those regulations have evolved over the time. So in UEMOA, the first regulation has been enacted in 1998, and it has been revised in 2010. And since 2010, this is the same regulation that is being applied in the UEMOA countries. In CEMAC, a first regulation has been adopted in 2000, and it has been significantly modified in 2018. This modification, this new regulation in 2018, brought several significant changes to foreign exchange regulations with respect to the opening onshore of offshore foreign currency accounts, with respect to repatriation obligations. We will obviously discuss about this quite in detail during this talk. The purpose of our talk today is also to discuss the last developments which occurred in December 2021. A number of regulations applicable to the extractive industries, meaning oil and gas and mining companies, have been adopted, and Lucien will explain how those regulations have modified the current applicable regulation. So now let's move to an overview and comparison between the UEMOA and CEMAC FX regimes. So we'll start with the general aspects, and we'll go through into the main aspects that are important in all our project finance transactions. Obviously, we will not have time to go through all of the items applicable in the FX regulations. However, we will stick to the most important points, which are how we can open onshore or offshore accounts in the CEMAC or UEMOA regions, how residents can borrow money from non-residents, and so on. So let's start with the general aspects. In both regions, the regulations distinguish between the UEMOA or CEMAC member states, franc zone states, and other countries. What is franc zone? Franc zone, it comprises CEMAC member countries, UEMOA member countries, and also France. And the regulation creates as well a distinction between residents and non-residents. What about, next slide, please, Lucien. Luc. What about settlement of external transactions? Both regulations also provide that it is mandatory to use a licensed intermediary for any transaction between a resident and a non-resident. Basically, it means that any transaction must go through a licensed bank in CEMAC or UEMOA country. So this is the general. These are the general aspects. Now let's focus to questions which are extremely important and are bankability issues in all of our project transactions. What about opening onshore accounts in foreign currency and also offshore accounts in foreign currency? So here the principle is quite simple. This is a prohibition. It is prohibited in UEMOA and CEMAC countries for a resident to open an onshore account in foreign currency. Obviously, if there is a prohibition, some exceptions can be obtained, and it can and those exceptions are implemented through authorization in UEMOA countries granted by the Minister of Finance, and in CEMAC countries granted by the central bank, which is the BEC. What about the offshore accounts in foreign currency? Here again, the principle is a prohibition, and I would say it's quite complicated to obtain an authorization to open offshore accounts in foreign currency. I would say that obtaining an authorization from either the Ministry of Finance for the UEMOA countries or an authorization from the central bank in CEMAC countries, it's quite complicated because the economic actors will need to justify the reasons why they would need to opt to open an offshore account, the way such offshore accounts will be maintained and operated. And another also aspect which is very important, and we will see in the next slide, is the repatriation obligation for exportation proceeds. This is again a very stringent control of the central banks, which, according to which all proceeds originating from exportation, for instance, sale of goods, must be repatriated in the regions. For the UEMOA countries, this is within 30 days, 1 month. For the CEMAC countries, this is within 150 days. So obviously, this is something which is very difficult to manage when we have an international project finance transaction, because very often we will have a debt service reserve account opened in foreign countries, in foreign currency. So in order to be in a position to keep those amounts in foreign countries, the resident will need to obtain the authorization from either the central bank in CEMAC countries or the Ministry of Finance in UEMOA countries to be in a position to keep these monies in offshore accounts. On the next slide, another topic which is also obviously important in the project finance transaction is whether it is possible for residents to borrow money from banks which are not registered in UEMOA and CEMAC. The answer is yes, indeed. However, there are a number of formalities. In UEMOA countries, all loans contracted by a UEMOA resident must be declared to the branch of the Ministry of Finance. This is a statistical declaration. Such declaration must be made prior to the disbursement under the loan. And also each repayment of the loans must be declared as well to the Ministry of Finance. Generally, those declarations are made by the local banks who are transferring the monies from the resident to the international bank. In CEMAC region, this is a little bit more complicated, I would say, because first, a third declaration has to be made to the Ministry of Finance and to the central bank 30 days prior to the first drawdown under the loan, and 30 days after the drawdown of the loan, it has to be declared again by either the borrower or the local bank. So very often we are asked the question by our clients, oh, well, what would happen if we don't make the declarations? So basically, the rule is the following. In order to be in a position at some point in time to reimburse a loan which is made in a foreign currency, such loan needs to enter into the zone. That's the reason why those declarations are important. So if those declarations have not been made, then it will be extremely difficult to get money in foreign currency to reimburse the loans in foreign currency. And these are the practical consequences. On the next slide, we are discussing about the sanctions. So the failure to comply with the provisions of the foreign exchange regulations there are obviously some sanctions, and in CEMAC countries, the authority to apply sanctions is the central bank, whereas in the UEMOA countries, the authority to apply sanctions are the member states themselves. So the sanctions could comprise administrative, monetary, and non-monetary sanctions, depending on the nature of the offense and the seriousness of the breach. I think I have now given you a broad overview of what are the CEMAC and UEMOA ethics regulations. I'll now just hand over the micro to Lucien in order for him to give you an update of the new new regulations for the extractive industries.
Thank you, Mariana, for the presentation. I'm gonna pick it up actually where Mariana stopped, basically on the sanctions and how this was the key element that pushes this discussion today following the entry into force of the specific regulations applicable to extractive industries. So basically, before the new regulation, the CEMAC regulation entered into force, the power for sanctioning breaches was still with member states. Now with the 2018 modification, we moved these authorities to the central bank. So basically the central bank now can sanction any violation of the CEMAC regulation without going through the state itself. This put the entire situation in a different perspective, whereas today we would need to comply with these regulations that, as Mariana explained at the beginning of her presentation, normally have to be applied directly in member states. So this change of authority to the central bank forced the brainstorming on, okay, how do we apply this to extractive industries, and is it adapted to extractive industries? So the specific arrangements are caused from a practical perspective by the specificity and complexity of the sectors. When we talk about the specificity of the sector, it's mostly that this sector exports most of the products. So the question of what do we do with export proceeds is very important in dealing with the foreign exchange regulations. And then we know that oil and gas and mining companies have to pay a lot of contractors and make a lot of payments offshore. And these payments are usually made in dollars. So to the extent that we needed to pay a lot of suppliers, we needed to make a lot of payments offshore, we needed to mitigate risks against foreign exchange currency, against the exchange rate, and against heavy administrative procedures that would require companies to go through the banks. This is one of the most important issues that was raised by extractive companies when they said that the regulation, the 2018 regulation, is ill-adapted to the extractive industries. Other topics that were raised, and we will get back to that in a bit, is the rehabilitation accounts. So what we call the RES accounts. The RES accounts have historically been always based offshore, and these accounts contain substantive amount of money that it should be used to rehabilitate the sites once exploitation is completed. Companies were worried about if we import now, if we repatriate these amounts locally, given the local instability that we have seen in some jurisdictions in CEMAC, how can we guarantee that this amount will not be subject to third-party seizures and end up losing this amount gradually over the course of the years, rather than making sure that the amount is there for its main purpose, which is to rehabilitate the sites. We're going to see how we dealt with these aspects. So if we can go maybe to the next slide, Luke. So to begin with, since the 2018 regulation entered into force, extractive companies voiced concerns on how these new regulations would hinder the applicability and the practicality of their businesses. So the CEMAC, the BOAC, the central bank, issued 2 consecutive notes which granted great periods. The first one was until end of 2019, end of 2020, and the second one was until the end of 2021. The reason why this was issued is because in most of these countries, the local codes applicable to the mining and oil and gas industry provide for provisions that are inconsistent with the provisions of the regulations. So typically, we would find in the mining code or in the hydrocarbons code in member states provisions that would allow the company to keep some export proceeds offshore and to only repatriate the balance of that account, and would allow to open a bank account without going through the strict process that is set out in the CEMAC regulation. So facing this inconsistency, and even if in theory it's the CEMAC regulation that should apply, a lot of companies voice concerns saying, this is creating instability. We don't really know how to proceed now that this regulation is changed and now is likely to be strictly enforced. So a lot of meetings happened between the stakeholders, meaning the member states themselves, the central bank, financial institutions, and some of the extractive industries. At the beginning of the negotiation, extractive industries were more hesitant to participate in negotiations, but over the course of the years, we saw that the meetings were more frequent and mining companies and oil and gas companies were participating more and more in those meetings. This led, after the second grace period, to the enactment in December 2021 of a set of texts, 2 regulations and 3 instructions that are applicable specifically to extractive industries. Now, on the next slide, we will see what are the extractive industries. Who are these companies? Basically, the regulations and the instructions distinguish between 2 types of companies. We have the upstream oil and gas sector and mining sector companies, to which the new regulations fully apply. But we also have the local subcontractors of these mining and oil and gas companies, to which part of the regulations apply. In particular, those that apply to subcontractors were justified by the fact that subcontractors themselves need to make payment in foreign currency, especially to license technology and to obtain some expertise that is not yet available in CEMAC member states. So the provisions that were applicable to subcontractors, as we will see a bit later on, are mostly for their right to open onshore bank accounts in foreign currency, but not for offshore bank accounts in foreign currency, although there are some exceptions. But the principle remains that for subcontractors, it is only it's only a right to open onshore bank account in foreign currency. Can we go to the next slide, please, Luke? So before we go into the procedures, just a quick word on this right to open onshore and offshore bank accounts. Mariana mentioned earlier that this right already existed. The CEMAC 2018 regulation already provided for a right to open a bank account subject to obtaining the authorization. In reality, however, and as Mariana mentioned, companies struggled to open these bank accounts. Sometimes there were no answers to the requests, but sometimes there was a clear answer that we would not want you to open an onshore offshore bank account. So a lot of companies hesitated to actually request for these bank accounts, especially that requesting these bank accounts were seen by these companies as a voluntary acceptance of being subjected to the CEMAC regulation, whereas local texts, whether the codes or the contracts, gave them more flexibility. And some of them chose to say, let's not willingly go and say we are subjected to this CEMAC regulation, but stick to the provision of our contracts and our mining codes. So the specific regulations aimed more at giving assurance to the companies that the process will be made properly and that bank accounts will be granted. Now, we know that some mining and oil and gas companies have requested to open bank accounts following the issuance of the new regulations. I don't know where we are now in that process, but we know that it has encouraged a lot of companies to actually fit in the process and try to apply it. The main advantage that was changed and that was given to mining companies is that now the application can be made electronically, and the bank has 30 days from receipt of an application to respond to it. They might request for additional information, which would suspend the delay, but within 30 days from the receipt, they will have to respond. And the receipt itself is received by the company upon submission of the electronic application. Can we go to the next slide for the duration of the authorization, which was also an issue, and the transitive provisions? One of the other issues that oil and gas and mining companies raised with the central bank was to say that our projects are long-term projects. We usually have a project for duration of anywhere between 25 and 50 years. And we cannot be subject to such uncertainty as having to renew our authorization to open and operate onshore or offshore bank accounts. And every 2 years, we will have to renew it and wait for an answer when the project didn't change and when the authorization was already approved. So the key change that was done with these specific regulations is that the authorization can be granted to the full duration of the purpose of the account. We think that this is the duration of the oil and gas and mining operations. And given that oil and gas companies and mining companies have not always complied with these regulations because they relied on their contractual provisions and local texts, the CEMAC now provided, the CEMAC regulation, the specific ones, provided now that companies will have 10 months from 31st December to comply with the regulation, and provided certain documents and information are complied with, these companies will not be sanctioned for any violation of these regulations prior to the date of entry into force of the new foreign exchange regulations. Another key topic is on the next page, is the timing of the repatriation. And the next one is on the next slide, but I'm gonna start already talking about it. We can go to the next slide if you want, Luke, is on the threshold and the percentage of proceeds that should be repatriated. So for both extractive companies and non-extractive companies, monies should be repatriated within 150 days from the exportation date, which is a reasonable timeline if we compare it to other jurisdictions that have similar requirements. We know, for example, that in UEMOA, this period is of 30 days, whereas it can go up to 360 days in Algeria. So the 150 days itself is not a time period that is not reasonable. Now, the key change that was made is what is the amount that has to be repatriated. The general UEMOA regulation, the 2018 regulation, provides that all amounts should be repatriated. You cannot make any deduction from these amounts. Whatever export proceeds you have, you should repatriate them locally and then comply with the provisions of the CEMAC regulation. Given what I've briefly explained before and the specificities of the extractive industries, it has now been accepted that companies will only be required to repatriate a minimum of 35% of their export proceeds, meaning they can keep offshore on the authorized bank accounts that were opened 65% of the proceeds. Now, at this point, the central bank has already raised an issue saying that this threshold should be reviewed and adapted as we move forward. So we expect that the central bank will try to push to raise the threshold over the course of the next few years. But for now, it gives the security of saying we can still operate our bank accounts, we can still conduct our operation, and we have the capacity of keeping offshore 67% of our proceeds. Another point was that it has been clearly provided that all amounts resulting from exploration activities or amounts relating to RBL or financing similar to RBL that were approved being as such by the bank can be kept offshore. The wording that is used in the instruction is a bit confusing in terms of what can be export amounts resulting from exploitation activities when we know that during exploration activities there is no exportation. We know from the preparatory documentation that this was intended to say that during the exploration phase, companies will not be subject to the foreign exchange requirements, and then they can obtain whatever financing they obtain offshore and use them. Now, the word used in France, in French, is issu des travaux d'exploration, which will probably create some discussion and confusion, but we feel with the supporting documentation of the preparatory works, there is enough argumentation to say that any amounts relating to exploration phase can be kept offshore. Now, the rest amount is the amounts that we talked about before, the rest accounts, which is basically, which now will have to be repatriated locally. And a deadline longer than the 10 months period provided to compliance with the CEMAC regulation has been provided for, which is 3 years from the 1st of January 2022. I believe this is it on our end. The last point was relating to payment of local suppliers. So this is basically the other exception that was given to local suppliers. What we should know in this respect, that now it is possible to make local payments from onshore bank accounts. It is not possible to use offshore bank accounts for now to settle transactions between extractive resident companies, but the fact that onshore bank accounts can be used to make local payments in foreign currency to subcontractors is already it already provides already a lot of flexibility to mining and oil and gas companies. I think that's it. If anyone has any question, please go ahead, including you, Luke.
Thank you, Lucien, Mariana as well. Thank you very much for your presentations, guys. It's really informative, and I hope everybody's really enjoyed that. We've got a couple of questions. Lucien, if I can leave you on the screen just for a little bit longer. First one is for you, I think. So question is, how will the new FX regulations in the CEMAC countries interact with existing mining and oil and gas contractual agreements, which usually include stabilization provisions?
Thank you, Luke. This, I think, is the big question. So today, the biggest question is to know how will extractive companies react to the new CEMAC regulation. So I'm going to give just a quick background on how we used to deal with that prior to the entry into force of the new regulations. So historically, before the sanctioning power were transferred to the central bank, we used to obtain waivers from the sanctioning authority, which was the Minister of Finance, of saying, we are in compliance with our oil and gas or our mining code. We are in compliance with our contractual arrangements. We know that there is inconsistency with the CEMAC regulation, but given that the Minister of Finance is in charge of sanctioning any violation of the CEMAC, we would like some comfort to know how we can carry out our project in strict compliance with the applicable regulations. This was possible to obtain in the past, especially that usually the Minister of Finance is a signatory of the convention themselves. Now, with the change of the authority to the central bank, this type of waivers is no longer possible, and now the central bank will be in charge of that. So we are faced with a situation where oil and gas and mining companies will wonder whether now they will have to apply the CEMAC or they can still raise the stabilization provisions that are in their contractual arrangements or in the mining code or in the oil and gas, in the hydrocarbons code, and say, well, the state guaranteed that nothing will affect my financial and economic equilibrium, nothing will be imposed additionally on me. And now you are imposing something that is a bit more complicated to deal with. So it is still a question, and we have no answer to that, to say, how strong will the stabilization provision be in front of a regulation that is supranational? It's not the state itself that changed its regulations. There is a regional organization which regulations apply directly locally that is changing its regulation. The preliminary analysis is that probably the oil and gas companies and mining companies would either want to negotiate with the state the applicability of the CEMAC regulation through an amendment to their existing arrangements, or they might say, well, even if the state is complying with the CEMAC, the state is breaching this provision under my contractual arrangement, and I would need to discuss with the state how to deal with that. So it's obvious that this question of how will the CEMAC regulation affect ongoing arrangement that provide for stabilization provision is still an open question. And I think in the near future, this discussion will have to be made with the central bank or the member states.
Super, thank you, Lucien. I've probably got another one for which I think might be for Mariana this time. Actually, Mariana, I'm going to just put you on. So the question here is, why can't the specific measures adopted for oil and gas industries be replicated for other economic actors such as energy and other infrastructure projects?
Thanks, Luke. This is a very interesting question, and I would say that it would make my life easier if those exemptions would have been applicable to other actors such as the energy or infrastructure for the energy infrastructure projects. I'm usually advising on those type of projects. Whereas Lucien is an expert in mining and oil and gas fields. And yeah, well, I have heard Lucien saying that, well, in the oil and gas and mining sectors, they have massive amounts to pay in dollars to foreign for the EPC or for other type of works. I would say that in energy and infrastructure projects, we have the same type of situation. If I may, I think that the main difference between the oil and gas and mining projects and energy or other infrastructure project is that actually the extractive companies are exporting most of the goods abroad, whereas on an infrastructure or energy project, the assets, I would say, stay in the countries. That would be one of the main reasons, I would say. But obviously, I would be happy if those exemptions are also applied to my clients.
Thanks, Mariana. That's really helpful. I've got a third question, actually. Maybe I'm going to put this one back to Lucien. Lucien, do the UEMOA FX regulations provide also for a specific regime for the extractive companies? So not the CEMAC, but the UEMOA.
Thanks, Luke. Currently, they don't. Currently, the UEMOA regulation is applicable to all companies. Similarly, we do not, however, exclude that UEMOA might in the future decide to follow the path of CEMAC, whether in respect of transferring sanction authorities to the central bank and then providing for a specific foreign exchange regulation that would be applicable to oil and to extractive industries. For now, UEMOA we're still handling these questions in UEMOA the same way we used to handle them before the sanctioning authorities were transferred to the central bank and CEMAC.
Thanks, Lucien. I've got a fourth question here for you guys, so I'll read it out. Maybe one of you can volunteer. With regard to the repatriation requirement, you referred to the exemption of repatriation for amounts arising from RBL financing. Lucien, maybe this is you. Does that mean that the drawdown under the RBL financing is not required to be repatriated, or is the provision wider and provides an exemption to repatriate any funds that will be used for debt service of the RBL financing?
Thank you, Luke, for this question. And this is basically one of the issues that will still need to be clarified in practice, how it is intended to be dealt with. Now, the wording that is used in the relevant article of the regulation, which for the person who asked the question, if you are interested to look into it, it's Article 4 of the new regulation #1, and it provides that the repatriation obligation does not apply to the following, and it says financial arrangements that are similar. I'm sorry, translating from French as I read. So it does not apply to financing arrangements of any type of funds that are backed by resources, commonly referred to as the RBLs. So when we read it, it seemed to be very broad, and it seems that there is no repatriation requirements in respect of RBL, meaning that the local company will not have to repatriate the full amount of the RBL locally. Hoping this answers the question.
Thank you, Lucien. Well, look, I think at the moment we've used up most of our time, and we've kind of gone through all of the questions we've been asked. So well done, everybody. Thank you to our two speakers again. So on behalf of everybody in the audience, I'd like to thank Mariana and Lucien. To everybody in the audience, thank you for attending. We hope this was useful. If you have any questions about the content of today's presentation, please don't hesitate to contact any one of us in the Trinity team. Once again, the video will be available in due course after the presentation via our website if you or any colleagues need to rewatch it. For the meantime, thank you ever so much for your time, and have a good rest of your day. Thank you. Goodbye.